Corporate governance relies on a delicate tension. The company pays the auditor, but the auditor must report honestly, even if it means exposing financial ruin. In India, Section 140 of the Companies Act 2013 governs this exact dynamic. It acts as the legal architecture enforcing an auditor's independence. Once a company appoints an auditor under Section 139, breaking that statutory contract before the term expires is not a standard human resources matter. The exit is strictly gated. This diagram maps 3 legal vectors for an auditor to leave early. First, voluntary resignation under subsection 2. Second, the company forces the auditor out before their term ends under subsection 1. Third, a punitive ejection by the tribunal for fraud under subsection 5. These 3 pathways exist to prevent companies from quietly silencing watchdogs and to ensure that watchdogs who abandon their post face immediate legal exposure. Looking first at voluntary resignation, an auditor cannot simply walk away. Submitting a resignation instantly triggers a severe compliance burden. From the exact date of resignation, the auditor is placed on a 30-day statutory clock. Within that window, the auditor must file Form ADT-3, detailing the precise reasons for leaving, to both the company and the Registrar of Companies. If the entity is a government company under Section 139(5), a third filing must go directly to the Comptroller and Auditor General of India. Missing this 30-day window triggers the strict liability matrix embedded in Section 140, subsection 3. As this scale demonstrates, the base penalty for failure to file is 50,000 rupees, or an amount equal to the auditor's remuneration, whichever is less. But the penalty compounds. For every single day the failure continues, an additional fine of 500 rupees is added to the balance. Prior to recent changes, this could compound indefinitely. The 2020 amendment introduced a hard cap, limiting the maximum penalty to 200,000 rupees. Section 143C ensures that an auditor's exit cannot happen in the shadows. Leaving the post forces a transparent filing to regulators, backed by immediate financial risk for noncompliance. The second factor, Section 140 subsection 1, governs how a company can force an auditor out before their tenure expires. To execute a preterm removal, the company must clear 2 procedural hurdles. First, they must pass a special resolution, requiring a supermajority vote from the company's members. Second, they must obtain prior approval directly from the central government. The state must review and authorize the firing. Before any action is taken under the subsection, the law explicitly requires the auditor be given a reasonable opportunity of being heard. There are specific timeline modifications for specified IFSC public and private companies. As this timeline illustrates, for these IFSC entities, if the central government does not communicate a decision within 60 days of the application, the law presumes deemed approval. The company can bypass the formal state sign-off. Once that 60-day period expires with deemed approval, the IFSC company has exactly 3 months to convene a general meeting and appoint a new auditor. For standard companies, the double lock requirement of a shareholder supermajority and state approval creates deliberate operational friction. It makes retaliatory firings exceedingly difficult. Even at an annual general meeting, quietly swapping out an auditor requires strict protocols. Under Section 144, appointing a different person requires a special notice. Upon receiving this notice, the retiring auditor has a proactive statutory defense, the right to make a formal, written representation to the company. The company then carries a dual legal obligation. They must state the fact of the representation in their notice and physically send a copy of that document to every member. If the company defaults or delays sending the copies, the auditor retains a fallback right. They can legally demand that their representation be read out loud at the general meeting. However, the statute anticipates the potential for abuse. The company, or any aggrieved person, can apply to the tribunal for intervention. If the tribunal is satisfied that the auditor is using this right to secure needless publicity or defame the company, it can order that the representation be suppressed and not read out. Section 140 subsection 4 provides a precise mechanism. It gives the auditor a platform to defend their professional record while giving the company recourse if that platform is weaponized. The final vector shifts from procedural friction to aggressive enforcement. Section 140 subsection 5 grants the tribunal sweeping sua motu powers. The trigger for this section is severe. The tribunal must be satisfied that the auditor has directly or indirectly acted in a fraudulent manner or colluded in any fraud involving the company. While the tribunal can act on its own, the central government can also initiate a fast-track application for removal. If the central government applies, the tribunal is bound by a strict 15-day timeline to issue an order, suspending the auditor, paving the way for a government-appointed replacement. A final order from the tribunal carries a devastating penalty. The auditor is banned from being appointed in any company for a period of 5 years, and this liability is contagious. Explanation I of the statute specifies that if a partner acts fraudulently, the liability extends to the entire audit firm. The 5-year ban applies to the collective entity. In addition to the ban, the auditor becomes immediately liable for further punitive action under Section 447, which governs corporate fraud. Section 145 operates as an existential threat. It gives regulators the authority to instantly dismantle the career and the firm of an auditor who breaks their fiduciary duty. When we view these vectors together, the architecture of Section 140 reveals its full scope. The statute functions simultaneously as a protective shield against corporate pressure and an unforgiving procedural trap for the careless. The double lock gate of Section 141 and the notification rights of 144 exist to insulate the auditor, while the strict 30-day timer of 142 binds them to absolute transparency. Sitting above all of this is the ruinous, firm-destroying capability of Section 145 for those who engage in fraud. For the statutory auditor, true independence is a rigid legal fortress. It is maintained only through unyielding procedural compliance and absolute professional integrity.